today's video, we are going to look into one of the most important cases in company's law, Macaura versus Northern Assurance Co Ltd, 1925. This case is often cited to emphasize the principle that a company is a separate legal entity from its shareholders. Even if someone owns all the shares in a company, they do not personally own its assets. This concept may seem technical, but as we will see, failing to understand can lead to major financial consequences. Let's break down the facts, the legal arguments, the decisions, and most importantly, what we can learn from this case. To understand this case, let's go back to 20th century Northern Ireland. Hi, Mr. Macaura. Mr. Macaura was a businessman who owned a large quantity of timber in Killymoon estate. Instead of keeping it in his own name, he decided to transfer the ownership to a company named Irish Canadian Sawmills Limited for 42,000 fully paid up shares, making him the whole owner of the company. Mr. Macaura was also an unsecured creditor for the company for 19,000 euros. Now, it's important to know that Macaura was the sole shareholder of this company, meaning he had the whole control over it. However, legally speaking, the company is a separate legal entity. Before this transfer, Macaura had insured all of the timber with a company named Northern Assurance Company Limited. Now, he insured it in his own name and not the company's, thinking he is the sole owner of the company and he owns most of the shares and he is the true owner of the timber. Unfortunately, disaster struck. A fire broke out and destroyed all of the timber. Naturally, Macaura turned to the insurance company expecting the compensation for the loss. However, the insurance company refused to pay. Their argument was that at the time of the fire, the timber no longer belonged to Macaura. It belonged to the company. Therefore, since Macaura had no legal ownership of the timber, he had no insurable interest for the timber. This led to the central legal question of this case. Can a shareholder insure the property of a company simply because they own all the shares? Macaura was not willing to accept the insurance company's refusal, so he took the matters to the court. His argument was that because he was the sole shareholder, so he was the owner of the company and he owned the assets. He claimed that they should allow him to claim the insurance. At first glance, Macaura's argument might seem reasonable. I mean, after all, a person is owning 100% of a share of a company, so doesn't that mean they own the assets too? Answer, legally speaking, is no, and the court was about to make that very clear. The case reached the House of the Lords, which ruled against Macaura. The court reaffirmed the well-established principle in company law that a company is a separate legal entity from its shareholders. Even though Macaura owned all the shares in the company itself was the legal owner of the timber. As a shareholder, Macaura had no right over that timber. Since Macaura had insured timber in his personal name rather than in the company's name, the court held that he had no insurable interest at the time of the fire. As a result, the insurable company was not liable to pay the claim. This ruling reinforced the fundamental concept in corporate law that a company is distinct from its owners. Just because someone is the majority or sole shareholder of a company, it does not mean that they have the personal ownership over the assets of the company.
This case established a few critical legal principles that remain relevant today. First, a company is a separate legal entity. It owns its property, enters contracts, and incurs liabilities separately from its shareholders. Second, shareholders do not own company assets. Even if a person holds all the shares, they do not have direct ownership over the company's property. Third, insurable interest is required for an insurance claim. If you take out insurance on an asset, you must have a legal interest in it at the time of loss. Otherwise, the insurance company can refuse your claim.
For business owners, this case serves as a cautionary tale. If you own a company and want to insure its asset, you must ensure that the company itself takes out the insurance policy. Otherwise, you might end up as Macaura, expecting a payout but receiving nothing. Macaura versus Northern Assurance is an important case in corporate law that emphasizes the separate legal entity of a company. It teaches us that just because you own a company, it does not mean that you own the property of the company as well. Understanding these principles is essential for anyone involved in business or in corporate law. I hope this breakdown clarified this whole case law for you. Thanks for taking out your time and watching this video.